let's talk for a moment or two about something that everybody who files for bankruptcy must attend. It's called the meeting of creditors. Sometimes it's called a Section 341 hearing because that's the code section of the code where the requirement in the law is placed. The meeting of creditors is not anything that you need to worry about. If your paperwork was prepared accurately, if you took the time to make sure that it was correct, you reviewed it before you signed it, the trustee will be present at your meeting of creditors. Remember, the trustee is the person appointed by the court to administer your bankruptcy estate, and they have a responsibility to examine you at the meeting of creditors and ask you certain questions. They want to know, first of all, they want you to prove that you are who you say you are. They want a current driver's license. They want proof of your Social Security number. That can usually be a Social Security card or a 1099 form that was issued by a company that you don't own. It can also be a document from the Social Security Administration that proves your entire Social Security number, not just the last 4 digits. At the meeting of creditors, the trustee can ask you if you assisted our offices in the preparation of your bankruptcy paperwork. If all of your creditors were listed, were all your assets listed? Was your income properly scheduled? They'll ask other things relative to transfers. Then the trustee at the meeting of creditors will ask you about things that they've discovered or didn't completely understand as they reviewed documents that they requested from you. Before the meeting of creditors, you must provide and produce for the trustee's office a copy of your most recent tax returns. You also need to provide for the trustee other documents that are requested. Usually those include bank statements for the last 3 months or so. They can ask for more, but that's a typical amount of time. They can ask for copies of titles to motor vehicle. They can ask for copies of other tax returns or other contracts or agreements or legal documents that you have in your possession that would assist them in determining whether or not there are any assets that should be administered, turned over to the bankruptcy estate and administered by the trustee. Now, it's not just the trustee that can come to a meeting of creditors. It's called a meeting of creditors after all. Creditors can come and ask questions as well. They rarely do. To pull a number out of the air, maybe 1 in every 400 or 500 bankruptcies does a creditor even show up to ask questions anymore. But you need to be prepared. If a creditor shows up, your attorney needs to be there to help you to make certain that the creditors aren't asking you to reach a legal conclusion for which you're not qualified to reach. To make sure that the creditors aren't oppressive or overburdened in the way that they ask their questions or the types of questions they're asking. To make certain that the questions that you answer are consistent with what your attorney understands you have explained in your meetings with your attorney as you're preparing the paperwork. When you get in front of a hearing like that, a lot of times it's easy to become discombobulated. I think that's a word. I think most people understand what that means. You just become nervous about the situation and you'll say something. Your attorney can be there to kind of redirect and correct and channel to make sure that you're not saying something on the record that can come back and bite you later on in your case as being something under penalty of perjury that you've testified to. It's much harder to correct something after the fact than to adjust or correct something at the time by clarifying it to the trustee or the creditor who's asking questions. Now, remember the meeting of creditors, once it's adjourned, it kind of sets off a date for certain things that are going to start happening. For example, creditors can object to a discharge after the meeting of creditors. They can object to a particular debt being discharged if they file that complaint within 60 days of the meeting first scheduled for the meeting of creditors. We'll address some of those things in a later video.